Hi and welcome to another episode of Delaware County Political News Meet the Expert. Today we are here with David Thirisulvum, board member of the National Crime Victim Bar Association. David Thirisulvum is going to discuss solutions for victims of crime. Sometimes the criminal justice system cannot bring satisfaction. David has alternatives. Dave, thanks for being a guest on Delaware County Political News.
Thanks for having me, Larry. Good afternoon. Good to be here.
David, tell us about your legal background. You've had a long, distinguished career. Give us a little bit of the highlights, please.
Legal background, I started at the Philadelphia Public Defender's Office for the first 10 years of my career. After that, I worked for insurance defense for an insurance company, defending them against claims brought by people. I did that for about 4 years. And then I worked for a couple of private law firms doing mostly plaintiff's work, motor vehicles, car accidents, things like that. And then I transitioned into my own firm, and primarily what we do now is we represent victims of crime in civil cases.
Dave, now tell us about your firm.
Okay, our practice is primarily representing victims of crime, people that are shot, stabbed, raped in various different situations in various different venues. Most of our practice is in Pennsylvania, New Jersey, and New York City. We do have some cases elsewhere. For example, we have a case down in Atlanta. And we can practice pretty much anywhere in the country.
You also had some military service, if I'm not mistaken.
Early in my life, a long time ago, I was in the Navy. And then after that, I went to law school down in Georgia. And then I moved up to Philadelphia to take the job at the Philadelphia Public Defender's Office.
Well, thank you for your service, by the way.
You're welcome.
You're not a DA. You are a civil lawyer.
Correct.
So you don't deal with criminal matters, but you do represent victims of crime. Explain, and we actually met at the National Crime Victim Bar Association. Tell us about the type of special niche in law that you have.
Right. As you mentioned, I'm not a district attorney. Their primary function is to prosecute the people accused of crimes. And they go after the person alleged to have committed the crime. What we concentrate on is the victims, and we represent the victims. Very often, the victims are expected to come into court, they expect to testify against the person that's alleged to have done something against them. And if the person is convicted or not, the victim gets to experience that, and then that's it, basically. What we do is we try and get some kind of additional measure of justice for the victim, try and get some kind of monetary compensation for them. Very often they're damaged either emotionally or physically, and yes, while you might get some satisfaction of being in court and seeing that the person that did this to you get locked up, it's quite a bit different when you actually have some funds to support you for the rest of your life, or as long as it takes to heal you or help heal you.
There are both some positives and negatives to the civil system. Let's break this down. What negatives are there in bringing the criminal claim against a perpetrator of a crime? Who does the DA represent?
The DA, believe it or not, does not represent the person who was injured, the victim. The DA represents the state, the Commonwealth of Pennsylvania, or whatever state that they're in. That's who they represent. They're a function of the state. And they are prosecuting people for crimes against the state. Now, because they committed something against another citizen of the state or another individual in the state, that person is the chief witness against the person that allegedly did this. So that's the position that the prosecutor, they don't actually represent the injured person. They represent the state against this person that committed a crime that violated state laws.
How can that turn out to be frustrating for victims of crime, David?
Well, a lot of times you hear victims mistakenly refer to the district attorney as my lawyer. That's my lawyer. Well, that's not your lawyer. And they're not really there to bring everything you want to the fore. And they'll tell you, listen, I can do this, I can't do this. Based on what I'm supposed to do to prove this individual did this crime against you, I'll need your testimony. But that's about it. After it's over with, maybe they can get some kind of, the judge to order some kind of compensation for your medical bills and things like that. If they can, while they're in jail, how they're going to do that, that's never explained. But they can get some kind of measure like that, but it's really far from enough to compensate these people for what they've really suffered.
And there's even more frustrating things that can come about. Suppose that victim says, hey, this is what I want. Go get me this result. Does the DA have to do that?
They do not. The DA is only answerable, it's usually an assistant district attorney, is only answerable to his boss or her boss. And the boss is the one that says, you can do this, you can make this kind of an offer, or you do not make an offer at all to the defense side to plea, or they'll say, plea this and get rid of it. So they're more accountable to their supervisor or boss than they are to the actual victim themselves. I've seen plenty of times where the victim wanted this case to go to trial and they wanted to have their say on the stand, and it just didn't happen because the DA explained, we don't believe it's going to happen, and therefore we're either not going to prosecute it or we're going to offer him some kind of plea so we can at least get something out of it.
Does the victim actually have to be consulted regarding the level of punishment for the perpetrator of the crime?
Well, the victim at sentencing, they have a right to speak, okay, a right of elocution, and the judge will really ask them if they have anything to say, and they'll say, yes, judge, this has harmed me in such and such way, and things like that and all that. And the judge can take that into consideration when giving his or her decision. For example, if somebody punched somebody and they got a red mark under their eye, that's one kind of punishment. If somebody punched somebody, they fell down and they got paralyzed from the fall, that's an entirely different kind of consideration that the judge has to make. So yes, it is weighed by the judge in the punishment, but it's not necessarily because of what the victim wants. It's what the judge takes into consideration, weighs, and gives. And very often, it's far different from what the victim actually wants.
In contrast, if the victim retains a civil lawyer like yourself, what is your responsibility as a representative of a victim of crime?
An attorney that practices in the area that I practice in, we represent the victim himself or herself. We are responsible and accountable to that victim. That is our client, and that is solely our client. We're not responsive to anything in the Commonwealth or the state or anything like that. Our client is our sole interest. And we are only trying to collect and make some kind of amends or some kind of a recovery on behalf of that client.
All right, so let's talk about the differences between the two. What benefits and limitations are there between the results you can bring and the results that a DA can bring?
The simple answer is DA can get somebody put in jail that did something wrong to a victim. A civil attorney cannot put somebody in jail. What a civil attorney can do is get some kind of monetary damages for the victim for what they have suffered. A district attorney cannot do that. A prosecutor cannot do that. They can only prosecute for the crimes, and if they're found to be guilty, then they go to jail or they get probation or something like that. Whereas on the civil side, we can only get monetary damages. We can't get any other kind of state action done against them.
And there might be some real limited restitution that a DA could bring, right? But it's minor, if I'm not mistaken.
A judge can order restitution, but just to give you an example, let's say somebody really hurt somebody, and the judge says, you deserve a couple years in jail for this, and puts that person in jail. And by the way, I want you to pay this person back the $15,000, $20,000 worth of hospital bills. Well, let's look at this practically. Unless this person comes from a lot of money, where they can say, tell their spouse or their parents, go get my bank account and pay this person off, more than likely, they're on some kind of payment plan, and $15,000, $20,000, first of all, when you're locked up in jail, you're not making any kind of money. Then when you get out, then you have to find a job, then you have to work, and then you have to maybe try and make some kind of compensation some kind of way. It sounds better than it is. I got the judge to give me compensation, but the reality is you're almost never going to collect it.
There is a different burden of proof in both. Could you talk about that a little bit?
Yes, the burden of proof that most people realize is the beyond a reasonable doubt that you have for criminal trials. It's a very high bar. The state has decided, and generally in the country we've decided, that before you take somebody off the street, take their liberty away, you got to have a pretty high bar that you have to cross. That's why you have such terms like assumption of innocence, you're assumed to be innocent, you have to be proven to be guilty, you have this high bar of beyond a reasonable doubt to reach in order to do that. For something like money damages, for a civil action, you have a lesser standard. because now you're talking about money, and you're not talking about taking somebody and taking them away and putting them out, locking them up for life or for a good period of their life. You're talking about money being exchanged, and therefore the courts view that, or basically the country as a whole, the laws view it differently, and they have a lower standard for that. Therefore, it technically makes it easier to win in that arena than it is in the criminal arena.
Still have to be more likely than not with your burden, correct,
Absolutely.
David?
You definitely, if you look at it in percentage points, you definitely have to be more than 50% in order to collect. And it's a tricky thing. In some states, for example, in Pennsylvania, it has to be over 50% or over in order to collect. If you're 49% found at fault between two individuals, you don't collect anything. There are some states where if you have 1% at fault, you don't get to collect anything, even though the other person's 99%, you don't get to collect anything. So it really varies from state to state. Some states do a balancing test, some states just say, no, if you contributed at all, you don't get anything.
And in our country, of course, we weigh our right to freedom so heavily that we give constitutional protections, the right to plead the Fifth Amendment.
Correct.
To take the stand, and now Miranda Rights.
Correct.
Right to remain silent.
Correct. You do not have to say anything. That does not exist in the civil arena. If you can't really take that right to remain silent. You pretty much have to. You have to be able to answer the questions in the court law.
David, you talked about the ability to gain compensation for a victim of crime, but there's limitations even to that in the civil arena, where you need a deep pocket, someone with the ability to pay a judgment. Can you explain that to our viewers?
Well, that's true. Unfortunately, a lot of the people that go around shooting, stabbing, raping people don't have a huge bank account that you can sue them for. And because that's what people naturally think, well, he did this to me or she did this to me, I should be able to sue them directly. Well, you're not going to get far if you do something like that. For example, if something like this, where somebody either assaulted, stabbed somebody, beat somebody up really bad, in a nightclub, in a bar, in a strip club, in something like that, well, you know what? The people that are throwing this event, they have certain duties and responsibilities towards the people that are on their premises. And they have to make sure that they're safe when they come and they spend money on their premises. And so they would be a more natural target due to their negligence. There would be a deeper pocket that you spoke about. That's just one example.
David, you've given some good general principles about when you can help a victim of crime. How does this look practically? When do they know to call a crime victim attorney? Can you give some ideas of cases that have been successful, or some good successful cases that have worked in the past?
Yes. The short answer is you should always call, because you really don't know. There may be some ways in which, because you don't know the laws, that the lawyer might know that you qualify for that you wouldn't know otherwise. For example, if somebody does something to you, let's say you get shot on the street. Go, well, I'm shot on the street. There's nobody to sue out here. There's no negligence on anybody else other than the person that directly shot me. Most cases, you're right. However, for example, we have cases in which just that scenario, the shooter was a juvenile. The shooter's gun belonged to the parents. Well, in that particular case, the parents did not keep their child away from their gun. They did not secure their gun properly. And so you'd have a different person to go to for negligence. And if it's a negligence standard that you're suing, the parents for not watching the child who's out there shooting people, then in that case, possibly you can get the homeowner's insurance to cover that.
So you just said negligence. Negligence is the same cause of action that a trial attorney uses for a car accident or slip and fall, isn't it?
True. That's primarily the reason, unless somebody's actually gunning their car towards striking somebody. Most of the times it is a negligent action. In these day and times, negligence is you find even more examples of negligence. I mean, back when you and I were growing up, we weren't, texting anybody while we were driving. We weren't talking on the phone when we were driving. Now you have all those kind of situations that are distracting people, and they're running into, different people, and, that's a negligent act.
Can you give other typical defendants who cause injury either directly or indirectly, where you have been successful getting compensation for a crime victim, even though that defendant wasn't the one who pulled the trigger, so to speak?
Right. I mean, one of the more common examples is the one I gave, where somebody assaults somebody in a bar or a nightclub, a strip club, or something like that. So you're on commercial premises, and when you're on commercial premises, then you do have certain kind of duties. That's not always the case, because if you're in a residential area, sometimes the laws are a little different. It's a little harder bar in residential areas to recover, because they don't have to be quite as diligent in protecting people that come up on their property that bars and nightclubs do, or even strip malls, for example. If you have things that are repeatedly happening on certain strip malls, well then, the owner needs to have some people parade up and down with, protecting the people that come up there to spend money. If they do not, after a period of time, he's saying, listen, this is a repeat offense that's happening on your property, and therefore, you are held liable for it. Other ways that people don't think is sleepovers. Somebody, an older brother, goes down there where the sisters are having their sleepover with their other friends, and something happens, sexual assault happens. Well, the parents are supposed to be watching for that. They're supposed to be responsible and making sure things like that don't happen. That will be a negligent action there. Even you have relatives, they go over to a cousin's house or whatever, and an adult relative either sexually abuses or rapes a minor child. Those are instances that happen, unfortunately, way too often, I'm sorry. And those are ways as well we can possibly go after homeowners insurance if we find that the adults in the house were negligent in watching what were happening.
You mentioned commercial property. If they know that a spot is dangerous and don't have security, how about if they know something is dangerous and they do have security, but yet an injury still happens?
Well, it's a little different then. If you do take measures to protect your people and something happens, then there's a decision made by the jury. Well, they did everything that they could. What more could be expected? However, if you hire somebody for security purposes, but they're sitting inside the coffee shop that's in the strip mall and they're drinking all the time, they're negligent in the performance of their duties that they were hired, well, that would be a case where it still would be liability.
Trial lawyers get a black eye for maybe raising car insurance premiums, homeowners insurance premiums, but in this crime victim arena, we've actually done some really good things. Can you give the major example where the trial lawyers have made society more safe?
Well, yes, there's a lot of ways this has happened. This has happened all across the board, and you're right. Lawyers are an easy target. You hear about these verdicts, and people just roll their eyes. You hear about people suing each other, and you go, why are we living in this kind of society? The fact is, let me tell you, people wouldn't change their behavior if it wasn't for the fact that certain lawsuits happen. A person wouldn't hire that security guard to protect his people unless he or she knew that, hey, I might get sued if this didn't happen. They wouldn't clean the snow off the area where everybody walks unless they knew somebody falls and gets a serious injury because I failed to clear off the snow. Well, guess what? You know what? I could get sued by some lawyer. And that's a direct way in which things are changed, behaviors change, society has changed for the better, because people take time to look and make more careful decisions about what they do, rather than just go about their business without actually thinking about people's safety.
David, can you give us some examples of famous crime victim lawsuits so our viewers can have an example of what we're talking about here?
Some of the examples that most people have heard of that's in the papers and things like that would be some of the priest abuse scandals that you've heard about, some of the abuse in the Boy Scouts and things like that with the Scoutmasters. These are things that have occurred, and they've occurred for decades, if not longer, without anybody stopping them. No other faction of society, police, legislators, nobody else stopped these people. It wasn't until they started getting sued by the trial lawyers. That's when they started changing their behavior. That's when it started bringing it to light. That's when the legislators actually started doing something about it. And that's when you saw the verdicts from it, and everybody started getting worried about it. Like, oh my gosh, if I don't change my behavior, if I don't start identifying these people that are harming the parishioners and things like that, these things are going to continue. And it's actually a good that's happened for society. Some people only look at the fact that it's been, this lawsuit. Well, it had a good result. They're taking their time and being a lot more careful as to who comes in contact with the kids in the church. You have other examples. For instance, you have let's take something like the 9/11 incident. It's a very unfortunate incident. But what some people don't know is a few people didn't accept the ready settlements that were offered. They decided they wanted to know more of the truth of what happened, and they actually hired an attorney to go ahead and prosecute and find out what happened in this particular case, civilly. And what they did was, they actually got to examine the film of when these hijackers went through the airport. And they saw that rather than get the 17-point check, they only got like a 5-point check. They saw areas where when these people's names were actually...
When you say 17-point check, this is just the procedure that the guards had at the airport.
Absolutely, that they were instructed and taught to do. And their training consists of like 2 or 3 days, rather than a lengthier training and follow-up training and things like that. So these people weren't doing their job effectively. Also, a couple of the names were actually on the terror list that the people had right behind their desk. And these people were checking in and they didn't match it up. So there were a lot of slack things that happened. Now, it may have gone the other way where now you have to take your shoes off and things like that at the airport, but you cannot argue that we are safer, and we're safer because these people pressed the points to make sure that people were held accountable.
So you made a really good point there. What you're saying is perhaps 9/11 in part occurred due to some carelessness of airport security.
Absolutely. Absolutely.
Can you give an example of where the criminal justice system failed crime victims, but the civil justice system was able to bring compensation?
Okay. The easiest thing I can give you, what probably everybody knows, is the O.J. trial. As you can remember, there was a prosecution, a long prosecution the entire country followed, and he was found not guilty. However, there was a civil action brought against him after that, and he was found liable in that. And that's to various different reasons. Either the laws are different, the bar as far as proof is different in that regard, and also he had to testify in the civil trial. He couldn't get around it. Okay, so you actually got to hear him, his version, and got to see whether you believed it or not. For example, I had a case right here where my client was shot in the face. It was a horrible crime. He was shot in the face with a .357 Magnum. And the person that actually shot him ended up getting off scot-free. But he came to me. He went to 5 different law firms. Nobody would take his case. We did some investigation, and we saw a possibility to make a recovery for him. And we did, and we got him a very healthy settlement.
David, the Delaware County Times covered a story where an assistant public defender filed a lawsuit against the public defender for losing his job because he wasn't pleading out enough of his clients. Apparently, he felt pressure from various public officials and his boss to keep moving his docket and plea a certain amount. When I say plea, of course, for our viewers, plead guilty a certain amount of his clients, which he, according to the article, he didn't feel were guilty, and they didn't want to take that plea. You were a public defender in Philadelphia for 10 years. Were you aware of any type of pressure to move your own docket along for your clients who were charged with crimes?
Well, this example you gave, unfortunately, exists around the country in various different public defenders' offices. And this is because you have a state or city official that has to move these cases in order to be able to being thought of as successful. Unfortunately, it tends to be somewhat of an assembly line kind of situation where supposedly justice is supposed to be served, but we're just processing and moving cases along. Now, you mentioned that I was in the Philadelphia Public Defender's Office. That's true, and fortunately, that office did not act that way. In fact, if they found out that all you were doing were processing or just settling cases, they would go ahead and pull you aside and say, we're here to actually try cases and represent our clients well. Now, I happen to know that about this particular office. Now, they're not the only ones in the system, however. When you go to the courtroom, the public defender is usually the most hated person in the courtroom.
Why is that? Explain that.
That's because they look at you as you're the reason that's keeping them there. You're the reason that's extending their workday. If you played ball, if you got rid of all these cases, guess what? Everybody gets to go home early. Everybody gets to go home for the day and then plan for the next day.
So you're saying that they hate the public defender. Well, who is they?
Everybody in the courtroom that's doing a job. They know that they have to be there. I'm not going to point out specifics, but that includes everybody, including the judge, the prosecutor, the bailiff, everybody. They all have to remain in that room until that list is done. And the public defender's office can either process it quickly and just plea it out, or they can fight for their clients and say, no, I'm sorry, there's going to be a trial.
David, I want to be clear about our discussion right now. You have never practiced in Delaware County. You have never practiced in the Delaware County Public Defender's Office, correct?
Not the PD's office, no, I have not.
So you don't know about any particular pressure of being a public defender in Delaware County, correct?
No, I cannot speak to that.
You're talking generally, and you're talking about your experience at the Public Defender's Office in Philadelphia, correct?
Correct.
How do you know about any type of pressure nationally or generally?
The public defender's offices, I've actually, around the country, we get an opportunity to meet with these people once in a while. You hear about these things in the news. We're more attuned to these kind of situations. Obviously, in other public defender's offices, you hear complaints about them. There's a general idea of public defender's office being less capable than, let's say, a private attorney, something that I don't agree with at all, and I've experienced the difference to know that that's not true. But there is a very real pressure that exists with public defenders as opposed to private attorneys. A private attorney can just saunter in whenever they like, make an agreement, smile at the judge, and they get a different kind of a treatment very often than the public defender that's representing 15 or 20 people on the list that could not afford a private attorney.
What is the obligation a lawyer has to his client? Explain that for our viewers.
A client has to be zealously represented by his counsel, whoever that may be. And that goes for any area of the law, whether it's civil, whether it's criminal, whether it's public defender, whether it's any area.
Where does that come from?
It comes from the oath that you take. When you take an oath to be a lawyer, you're charged with zealously representing your client. If you cannot do that, don't take on clients. That's what you have to do.
And who is the client of a public defender? He's paid by the state, right?
Right. His check is probably signed by somebody whose authority derives from the state. Yes, that's true.
So let's get this straight. The DA represents the Commonwealth of Pennsylvania.
Correct.
Who does the public defender represent?
Well, the public defender actually is a department created by the government, either state government or city government.
To represent,
or combination.
To represent who?
To represent the accused.
Not the state.
No, not to represent the state's interest, to represent the individual's interest. That's true. The individual accused, that's who's supposed to be represented, even if it's to the detriment of the state.
But in that article, this guy was fired for not processing claims fast enough. Who was he not listening to when he got fired? His supervisor or his clients?
Well, if you believe the allegations to be true, he's alleging that he was fired because his supervisor felt that he wasn't processing claims fast enough. Processing the cases fast enough, either through pleas or some kind of a quick method to get rid of him. If you believe that to be true, and he says that this is the pressure that came upon me, well, that would have obviously come from, a representative of the state, which would be improper. Anybody will tell you that is improper.
And you mentioned, David, from speaking to other public defenders, this is not unique to Delaware County. This is something common to other public defenders' offices.
Well, yeah, each public defender office has its own character, its own ethos, if you will, and way of doing business. And you very often hear this complaint about public defender offices being overwhelmed by the number of cases that they have, because there are just so many defendants to take on and so few lawyers to represent them and so few judges or courtrooms to process these in, and everything gets backed up. And so yes, the solution that people would like to see is just rush these people through the courtroom process.
What relationship does the criminal justice system have to the mass incarceration of low-income individuals, in your opinion?
Well, if you just go back to what we were just talking about, not everybody gets a public defender. Matter of fact, you have to be lower than a certain level that they designate on the economic scale before you qualify to get a public defender. Therefore, that automatically means that you're on the lower strata of the economic scale. And these are the people that tend to be represented largely by public defender's office, and they're the people that might get processed through, as you just mentioned, by certain public defender's office that carry on this kind of behavior. So yes, that would be an occasion where it would be concentrated more in the lower economics scale of the public.
Assuming that there is some cause and effect, what solution would you see to this issue?
But I don't know that there's an easy or ready solution. Obviously, if you put a premium on zealous representation, and at the same time you put a premium on quickly processing these cases through the system, you're going to have a conflict, just an internal conflict right there. So they can't coexist. You can't have everybody have their day in court and have a jury trial that takes 3 days or 4 days when maybe 4 or 5 cases out of 7 may settle and take a plea of some kind. So it's a combination of the two, but you just want to make sure that the people don't get lost in the process, that the same kind of consideration is given to the person who can afford a high-priced private lawyer. The same kind of consideration is given to a public defender's representative as well. Now, is that a solution? I don't know. I think those considerations have to be there. Other than building more courtrooms, hiring more judges, doing other measures or taking other measures that keep people from getting in the system in the first place, I really don't know what kind of solutions that you can do. That may be up to our legislators.